patience and welcome to the Labor Center. My name is Derica and I'm with Working Partnerships USA. We are very proud to have Professor William Gould from Stanford, and he'll talk a lot. Ben is going to introduce him in a minute, who has written this lovely primer on labor law for folks like me who are not lawyers. I'm the only lawyer up here, non-lawyer, sorry, up here today. And we're very happy to have Ben Field from the South Bay Labor Council help us moderate this important discussion. So the Social Innovators series for us, this is the fourth year of doing it. It's really an opportunity for us to bring together leaders from Silicon Valley, that's you all, to hear from different speakers about interesting topics. And I am particularly excited about the topic of labor law, I think, as an organizer. Because as we look at the future of the labor movement, and as we really think about what the pathway for the middle class looks like for my kids and for the next generation, I think what the labor movement grows up to be and look like is hugely important for us all to be tackling. And the idea that labor law has really restricted and been narrowly defined in our lives, and really we need to figure out a way to go around labor law to organize. And I think that this discussion is going to be really interesting because we're going to get to hear from somebody who was on the inside, who's able to give us a sense of what the implications are for, especially, I hope, some of the more recent decisions that we've seen just this week, both in the recess appointments issue that recently happened. The Supreme Court next year is going to look at Obama's recess appointments to the NLRB and what the implications of that are for us. There's also a recent decision this week on the definition of a manager and liability for, I don't actually understand the whole issue, but it's not good for workers. And so what I'm hopeful for is that we can have a really good discussion. We're going to have Ben kick us off with some questions that these folks have discussed that will allow Professor Gould to get into some of his book, and then we're going to open it up to all you guys. All right? Thank you, Ben.
Thank you, Erica. And welcome, everybody. Welcome to the House of Labor. Always a pleasure to see a good crowd here. I'm looking forward to an interesting discussion. And I think, as everyone here knows, Professor Gould is one of the nation's top experts on labor law. He was the chair of the National Labor Relations Board during the Clinton administration. He has had a varied career, now teaching at Stanford, but he has also, outside of his experience as a practitioner on the National Labor Relations Board, as a judge on the National Labor Relations Board, he's been involved in various other interesting efforts, all tied to labor. Alternate organizing strategies and professional sports are just a few of the many areas that he's touched on in his very long and extraordinary career. So let's get it started. Professor Gould and I have gone over a number of questions that we thought we would discuss, and then there'll be time for you all to ask some of your questions. And I want to start with a question about one of your priorities when you were on the National Labor Relations Board, when you chaired the board. One of your priorities was to make the board more of a rule-making body, and you tried to institute a number of rule changes that would have accelerated the speed of National Labor Relations Board elections. I wonder if you would kick us off by talking a little bit about that effort, its importance, and how it came out.
Well, thanks very much to all of you, and I apologize for doing something that I have done a lot of things that law professors do from time to time, forgetting things various places. But this is the first time I've lost my keys to my car, so I'm really sorry that. And the car is a car that's mentioned in an earlier book that I wrote about my tenure at the NLRB called Labored Relations. Because I felt that my relations were so labored with just about everybody in Washington. And it was quite a struggle and a very interesting time. And one of the things I began the book with was by saying how I had bought this lovely car, this Chevy Camaro, 1994, which I still drive to this day, and I wanted to bring it down here, come whizzing in here, and I lost the keys and had to jump in another car that is just running out of gas. So I hope I'm not. I really hope I'm not running out of gas, and I really am grateful to all of you for waiting for me. The big problem with labor law always has been that justice delayed is justice denied. And that was true. My boss at the Labor Board, when I first started there in the 1960s, was the chairman of the NLRB appointed by President Kennedy. And I remember in his testimony, he said that the big thing I want to do is to expedite the administrative process. Because the problem is that the reason we have very ineffective remedies for violations of law, they're really in the form of slaps on the wrist. And as I say sometimes in my classes, go thou and sin no more, but we're really not going to do anything about remedying that. One of the problems with the ineffective remedies is the speed. You know, the longer these cases take to be resolved, the weaker the remedies look. If we could get people back on the job who've been unlawfully dismissed within a few weeks or a couple of months, well, then the lack of treble damages, the fact that we only have back pay and reinstatement, that wouldn't look so bad. But when it goes on for longer periods of time, it does. So I tried to do a number of things. I tried to engage in so-called rulemaking, which were designed to do, first of all, to expedite the administrative process, move the whole machinery faster. We provided for bench decisions by administrative law judges. If there's an unfair labor practice case and you have a case, where you're claiming or somebody in your union is claiming discrimination, you come before a so-called administrative law judge in the field. Now, we say, why do we have to, most of these cases involve facts. They're very tough cases. Who's lying? Who's telling the truth? These are the toughest kinds of cases, but they don't usually warrant the filing of voluminous briefs by lawyers on both sides. So what we did was to give the administrative law judges the authority to eliminate the briefs and to rule directly from the bench or to rule within 72 hours of the time that the hearing was concluded. Was I successful? Well, at the time I was chairman, I was successful. I think that the use of that machinery under both the Bush board and, sad to say, even the Obama board the use of that approach has declined appreciably. I ran into an administrative law judge at a meeting in San Francisco, and he said to me, he said, you should have done what Obama did. You have to really stay 2 terms to get something done. I went into Washington with the view that I wanted to only be in Washington 1 term, nearly 5 years. That was enough. But it's not really enough when it comes to seeing this kind of thing through beyond because it takes a lot of time just to get this stuff off the ground. Well, another thing I tried to do was to, through rulemaking, expedite elections. There are so many cases that come up where a union is going to organize, let's say, Marriott's. And there are 15 Marriotts in the Bay Area. And so the union has organized 1 or 2 of the Marriotts. And the Marriott says, oh, well, let's have an election in all the 15, well, we know what's going on there. The Supreme Court itself, in a case that I cite in this book, has described the fact that everybody is maneuvering for advantage, but for a half a century, we've been saying that the smaller unit is the unit in which you go, absent unusual circumstances, and that's the way the employees get a vote. Because if you agree with Marriott and say that the vote is going to be in all 15 Marriott facilities, they won't even get a vote, because there won't be, you have to have 30% of the employees in the unit to support a vote, to trigger an election. So that's it. But, I said absent unusual circumstances. Employers can rebut this presumption of the smaller unit, the election in 1 or 2 Marriotts. So I said, hey, very simple. Let's devise a rule which says if that second Marriott is more than 5 or 6 miles away, then it's out. You just have the election in the units that the union is petitioning. So all we have to do is, we don't have to have a hearing that takes up months. We just get an odometer, see? And then we said, another issue that arises, well, that a lot of employees are going back and forth between these Marriotts. So we get a status that we said, if 20% are going back and forth, then we'll widen the unit. It's get a statistician and an odometer, and no hearing necessary. But the GOP Congress, which wasn't, it's interesting to see Dole go on television and say, oh, if we only had the good old days of the 90s, the Republicans, and it's true that these guys are much worse. But, they precluded us from spending one dime on the implementation of this rule. So those were approaches that I took to move forward. One of them, I think, speeding up the unfair labor practices, that was more successful while I was there. The speeding up the elections got nowhere. Well, you see, the Obama board is trying to speed up elections now also, and with a much more ambitious approach than mine, but they are also stalled. The courts are refusing to enforce their rules, which are being challenged. And of course, you may know that in a very significant approach, the Obama board said every employer has to post a notice advising employees of their rights. Every employer throughout the country, because the employer said, oh, no. Why do they need to know what their rights under the National Labor Relations Act are? And the Obama board has thus far had really heavy sledding in getting that rulemaking initiative, which I described a little bit in the book, implemented.
Well, I do want to ask you about the next question we discussed, which has to do with separation of powers and the NLRB, but let me just pick up on the thread of your last answer instead and ask you first about NLRB elections. As you pointed out in your book, there has been a decline in the number of NLRB elections. It's largely because of the great difficulty in getting those elections. And so many in the labor movement have proposed an alternative, card check neutrality, and that's an idea you've written a lot about and somewhat critically. So can you tell us what your thoughts are on card check neutrality and why?
I have long advocated the right of unions and employers to voluntarily enter into neutrality agreements, which could be based upon either card check or elections. But I did take the position during the debate on the employee free choice bill that card check was a mistake and that we should go towards expediting elections. Why did I do so? One, I believe that the election, the secret ballot, is in fact the best way to express free choice, and I think that the public, as well as workers and employers in the workplace, believes that as well. The problem with the elections is that they take too long, and that during that period of time, the employer can use delay to engage in anti-union propaganda, which will undermine the majority support that the union has. I also think another way in which, so I welcome what the Obama board has done, trying to mandate quick elections. In Canada, they have elections right over the border in British Columbia. They have elections within 10 to 15 days of the time that the union files the petition. That is what we should have here. Now, how can we have that here? We have it. We can have it here. You know, there are all kinds of issues that arise during election disputes. Who should vote? Who's a supervisor? Who's a manager? What is the unit going to be? The kind of thing we were just talking about in connection with Marriott. So the board can come to an expedited ruling. The union says, hey, we think the one or two facilities of Marriott is the appropriate unit. Have the election right away within those 10, 15 days in that place. If prima facie, on the face of it, it appears that that could be an appropriate unit. And then, after the union is certified and the ballots are in the box and can't be changed, then you let the parties fight it out as to whether the board's whether this prima facie finding, this on the face of it finding, should be preserved. You mandate the employer to bargain collectively with the union while this dispute about the unit is going on. And the last point I want to make in this connection is that there are less disputes about the way people mark their ballots, far less disputes than the way they mark their authorization card. And of course, there are all kinds of disputes about the circumstances under which people mark authorization cards. Oh, this guy threatened me. Sometimes somebody will say one thing one moment, and then the boss comes along and says, hey, look, you really didn't mean to sign that card. Oh, no. Okay. Good. So there always will be those kinds of disputes about what the employee intended. Really, there are a few cases, and I talk about them in this primer, where there are disputes about the way the ballot is marked. But rarely is that the case. Now, one thing you have to take into account in looking at this whole election process and the way the cases have gone, there's really nothing that we can do about this absent a constitutional amendment, is that the big problem is employer anti-union propaganda. Remember I said this before, during this period, this lengthy period of time. If you speed the election up, then you diminish the impact of that in a 10 or 15 day period. Ben mentioned the fact that I was a so-called independent monitor involving a big British multinational company, first group that came into the United States, and they bought up Laidlaw Company, they bought up Greyhound, and the Teamsters were organizing them, trying to organize them, and some other unions, and they represented about 18% of the workforce. they authorized me to issue public reports about any allegation of anti-union discrimination within 30 to 60 days of the time that the complaint was filed. And they were mandated to respond. They pledged neutrality. They pledged that they would not engage in anti-union campaigns. So I was independent monitor in that arrangement for 3 years. When they started, the unions represented 18% of the workforce. When I left, they represented 82% of the workforce. So this left me with a view. And the only way that these employees, under this arrangement, could test their loyalty to the union could be tested was through an NLRB secret ballot box election. So the election is not the problem. The problem is delay, and the problem is employer anti-union propaganda.
I'm going to skip around a little bit. I'm going to ask a couple more questions, so start getting your questions ready. I know that several of you have them. The NLRB is now at the center of perhaps the most important separation of powers case of the generation. And it's arisen out of an attack on the NLRB. Can you tell us a little bit about the politics and the law of that case?
Yes. The politics of it are this. I'll try to be brief with this, but can't understand this case without understanding the context and the circumstances. President Clinton nominated me to be chairman of the Labor Board in 1993. And as a result of a book and some other things that I had written and said supporting a strong National Labor Relations Act, my confirmation was delayed for almost a full year. And when the Republicans finally agreed not to filibuster my nomination, they did so. They said to President Clinton, only if you will appoint other people to the board who are sympathetic to our point of view. And initially President Clinton said, no, you got to confirm Gould first, but then you could see that they were going to block this thing indefinitely with the filibuster. They went ahead and arranged for other people to be appointed. This began in 1990. I'm sorry that this is one of my legacies. This began in 1994, a process called batching. That is, you put a group of people together who are acceptable to both sides. Never before in the history of the NLRB, since the Taft-Hartley amendments in 1947, had more than one nomination been voted upon at a given period of time. Now, what happened is that from that moment on, the nominations were back under Clinton, under Bush, of course, and here's what's happened with Bush. Some of you may remember that towards the end of the Bush board, they engaged in the so-called September Massacre, 2007, where they systematically reversed case after case that we had decided in the Clinton era. And so what the Democrats did was in 2007, they began a practice of conducting so-called pro forma sessions in the Senate during recesses so that Bush could not make recess appointments. See, the Constitution of the United States authorizes the president where the nomination has not been confirmed with the advice and consent of the Senate, the advice and consent of the Senate, to make recess appointments while the Senate is in recess, so that government can continue to function. See, we had no appointments between 1994 and 1997 confirmed by the Senate. The only way that the NLRB was kept afloat during most of the time that I was in Washington was through recess appointments. So, the Bush board got so bad that the Democrats in the Senate began to conduct these pro forma sessions, and what they would do is, Senator Reid was the sponsor of this, the leader of the Democrats. They would go on the floor and then simply call the Senate to order and then adjourn. There was no business. The Senate was not conducting any business. So they stopped Bush. See, Bush didn't really care because the Republicans don't care about the labor board. The Justice Department advised Bush that he could challenge these phony pro forma sessions that were being engaged in by the Democrats. So then the NLRB goes down to less than 3 members. The Supreme Court says in 2009 that the board can't function under the statute with less than 3 members. It invalidates everything the board does between 2007 and 2009. Enter Obama. Obama tries to get some people nominated and confirmed. He immediately runs into problems, particularly with Mr. Becker, who was counsel for the SEIU, and McCain. You may have seen some of those hearings on television, and McCain really, again, you know, I look back at my time in the 90s and I say, I felt as though they were very tough with me, and you know, I think my wife said to me once, you would think that they would treat a prisoner with more respect than some of the things that they say. But look at these guys now in this period, this Obama period, and I feel that, I look at what McCain did to Becker in the years. So Becker could never get confirmed. They refused to confirm most of the nominees of that President Obama put forward. So now, in late 2011, I wrote an article in the New York Times saying, look, Mr. Obama has got to appoint some of these people. January 3, a new Senate comes in for a new session, convenes in 2012, at the end of 2011, 2012. January 4th, they adjourn. And they say, we're not coming back till January 23. President Obama on January 4 makes a recess appointment. Now, complicated, you know, I don't want to get too much inside baseball here, but a complicated feature here is that you may be thinking of this, and that, hey, the Democrats control the Senate. They're not going to engage in these phony pro forma sessions, and they're not, now that Obama's in. But the House, there's a provision in the Constitution that says the House and the Senate can only leave if each gives consent. So the House, every day, the House is, a member of the House is going to the well of the House and saying, call the House to order, no business to be conducted, I'll adjourn until tomorrow. And same thing tomorrow. So, from January 3 to 23, they're not there. So Obama appoints 3 people to avoid a collapse of a board, which is what happened in the Bush era. Bush didn't care, but he appoints these people to. So this is challenged constitutionally. Now, let me try to boil this down quickly. The judge, this was decided, there are 2 cases now. One is from the Court of Appeals in the District of Columbia. The other is from the Court of Appeals in the 3rd Circuit in Philadelphia. The one in the 3rd Circuit, you know, if I brought it here, 150 pages. It's a lot of reading material there for you. You know, it's like, you know, it reminds me of Archbishop Tutu from South Africa. You know, said when he came to Grace Cathedral, he said, "No, I don't want to be one of those priests who you know, who goes on and bores you and puts you to sleep." He said, "I don't want to be like the priest in the Anglican Communion. You know, priests get married." His wife says to him, "Darling," Archbishop Tutu says in his falsetto voice, "Darling, would you please read me one of your sermons? I'm having difficulty going to sleep." So, you know, we could talk about these cases a long time, and I don't want to put you to sleep, but in essence, the provision in the judge holds, the District of Columbia holds, that Obama's recess appointment was unconstitutional because he can only make inter-session appointments between the two sessions of the Congress, not intra-session. And since Congress had convened on January 3, and Obama appointed them see, this is really, you know that I won't fall afoul of the Archbishop Tutu syndrome. So, since Obama made the appointment on January 4, it's unconstitutional because it's intra. And how does he come to this conclusion? He says the Constitution speaks of a recess appointment in the singular and not in the plural. Now, there's only one little problem. There's a great Supreme Court justice who once said, controversial Supreme Court justice, but I think a great one still, who stood the test of time, Justice Oliver Wendell Holmes, who said, he said, "A page of history is worth a volume of logic." A page of history is worth a volume of logic. Now, here's the page of history in this recess controversy. Since 1867, 400 intra-session, during the session, when the Senate is in recess, these recess appointments have been made. Since the end of World War II, 300 appointments have been made. Now, of course, these appointments have increased as the polarization has increased between Democrats and Republicans. By the way, of course, this doesn't only affect the Labor Board, this affects government generally. Because, you know, the Republicans are saying, hey, we don't like the Dodd-Frank bill. They lost. They didn't have enough votes. But, so, what do? They engage in this phony pro forma adjournment technique to deny Obama the opportunity to make an appointment during the recess, and they filibuster during the session the attempt to bring it on the floor. So, this is the way. So you got to deal with us. They say, now, if you want to change the dynamics, you got to deal with us. You got to appoint the guy that we want. We don't want one guy in charge of the Consumer Protection Agency. We just want a board. You know, they want to do the same thing to the Consumer Protection Agency that exists with regard to the NLRB. We'll get some of our people. Then you got to bargain with us about who the people are going to be. Court of Appeals for the District of Columbia said, well, it's true that many presidents have made these recess appointments. By the way, all of our NLRB appointments were recess appointments during the session, intra-session appointments. It's true that presidents have done this since 1867. But between 1789, the time of the Constitution, and 1867, there were no appointments. And these people were closest to the thinking of the framers of the Constitution, since the Constitution was fashioned in 1789. I kid you not. Now, Supreme Court on Monday agreed to review this case. Everybody wants, both sides, wanted the Supreme, because what's happening, some of you may have run into this, is that what's happening is that employers, and some unions have done this too, the NLRB subpoenas the employer? No. in the court. We'll go to the district, if you try to subpoena us, we'll go into the District of Columbia. See, any case involving the NLRB can go into the District of Columbia because that's where the offices of the NLRB, the principal offices of the NLRB are. So that's the problem. So basically, on any case where there's any controversy before the NLRB, shut down. You can't, give us your payroll information. Let us see who's in here. Let's see how you treated this guy as opposed to that guy. No, I won't give it to you because you can't get it. You can't get a subpoena enforced because you're not lawfully constituted. That's the situation we're in. We hope that it would be a brave man who would come to you tonight and say and predict with certainty how this case will come out before the Supreme Court. I think that this issue is I've tended to, in some of my remarks, ridicule the other side, but it's going to be a very close case, and it wouldn't surprise me in the least if it's a 5-4, one of these 5-4 decisions. If the administration loses this case, then the Republicans are going to say to Obama, okay, you can have your NLRB. We're going to tell you who to put on it. So that's the situation here. Now, I don't like to come to meetings like this and end on a down note because I think that there is so much potential for reform in the country. I think that and you as in the labor movement are such a vital element of democracy. I think one of the things we talk about the decline of the board and the problems that the board has as a result of these kinds of cases. But look, how did this arrangement that I described involving this British multinational come about? You know how it came about? The Teamsters, they went over, this British company, they went over to Scotland and they started passing out leaflets at the shareholders' meetings, and they started publicizing some of the things that had happened in some of the facilities. And so, some of the shareholders got very upset. Not enough to constitute a majority by any means, but they got to some of the corporate people who thought of themselves in Scotland as good citizens. And I remember the CEO of the company came to me and said, I'm not like that. This is unfair, what they're saying about me. We got to establish some kind of system that will be credible. Now, but you only get a system like this through pressure. And you only get a system that will deliver on these critical issues, expediting, providing for neutrality, if you go out and fight for it yourself. And so you're vital in this respect. And I think that is, notwithstanding all the horrors and difficulties of Washington that I and others since then have experienced, that's the message I want to leave with you tonight. And I really wish you Godspeed and in your work in doing this, and I welcome any questions you have.
Okay, so now we're going to open it up. And so if you have a question, raise your hand. I'll have you stand up and please state your name first. And let me just be kind of an organizer here and say, not comments, questions. Jimmy, I see you.
Jimmy Kelly, I'm with the Jimmy Kelly at Key 6157. You mentioned that you got a report from the Philadelphia Report, 150 pages. Well, I used to pass out the National Labor Relations Act in my classes, and it was about this. The problem that I see with the labor movement is as we become litigants as opposed to organizing activists, we put ourselves in jeopardy. That there was a time in the 30s when we were more active and more vibrant in the street, and by turning over labor peace into the courts, we got ourselves in a situation today where we have very little power.
I think there's, I think that there is something, I think this is a very perceptive comment, that's something I subscribe to very much. Look, you look at most of the union membership gains in the 30s and 40s, big gains, going into the 50s. At one point, there was more than 35% of the workforce was represented. Now it's 11. And in the private sector, it's less than 7. So now here in California, California has done pretty well. California has made modest gains, but made gains as the rest of the country is declining. And I couldn't agree with you more that you're only able to use the law as an adjunct. You've got to go out, as I said, just with this situation that I was involved in First Group, the company wasn't going to give that to them. They made things difficult and embarrassing for the company in Scotland. They knew how to go about it. I don't know why more things like this haven't happened since.
Claudia.
Claudia Show, Betsy, Youth 521. I was wondering, a retiree, I was wondering how we can put enough pressure on them, since we've been running into these roadblocks, to actually get the right things to happen. I mean, what kind of pressure can we get that is going to actually be able to work and worm around these dirty tricks of theirs?
You talk about it, the employers. Well, as I say, it seems to me that there are a number of things that either labor is not doing or should do more of. One is to make use of, look at what the UFCW is doing vis-a-vis Walmart. We're to promote employee groups that are not caught in the crosshairs of union organizing, but can be a listing post and be and perhaps, the verdict is not yet in, be a building block for more full-fledged organizing. I don't know how successful that's been there. This is being tried apparently at Target now. Another thing that I never understood, in 1996, my board held that unions could provide free legal assistance to workers during organizational campaigns when it comes to minimum wage legislation, OSHA, anti-discrimination legislation, race, sex, sexual orientation, you name it. Why aren't the unions diving in there? And the employers, some of the employers, the non-union employers, have established these non-union arbitration systems. So, next time a guy has a problem in the plant, the company says, "Oh, you can't sue us in court. Go to arbitration." We'll represent you in arbitration. Now, this will drive the employers crazy, but I think that unions haven't made use of this 1996 decision of ours. In a way, it's amazing that this kind of thing could even wind up as a litigated issue, i.e., can unions give free legal assistance during organizational campaigns? The idea, the legal issue, when I talk to foreigners about this, they can't believe it. The legal issue is the union giving them, neither side can give a so-called benefit. If one side gives a T-shirt, this is what I call T-shirt litigation. This is one of the things that's driving us crazy. Both, when unions give T-shirts or employers give T-shirts, who cares about this kind of stuff? But and similarly, it seems to me, this is what we said about the provision of legal assistance. This is vital. This is important. So unions should be doing this. Unions, I think, should be, and I think many are, working with community groups. Why is it, secondary boycotts are prohibited, but secondary leafleting is not. You can go to the company that is doing business with the company that you have a dispute with and leaflet and say, hey, Mr. So-and-so, you know, is this the company you want to deal with? Here's what they're doing. Here's the kind of company that they're dealing with and that they're gaining financial advantage from. So the objective here should be to try to get, where possible, neutrality agreements. There is an issue going before the Supreme Court. This is another one you want to watch, where there's a provision of Taft-Hartley that says, that prohibits an employer from giving a thing of value to a union. And the reason for, this is the language of the Taft-Hartley amendments, the reason was that, okay, you know, we got our union leader, we'll pay him off and keep him quiet so he won't represent workers. But what the employers are trying to do now, the National Right to Work Committee is in the forefront of this. They're saying, oh, if you enter into a neutrality agreement with the union, allowing the union to distribute literature where the labor board wouldn't require you to allow them to distribute literature, you're giving something of value, which is unlawful. And that, most of the courts have said what you said, that that's crazy. But the Court of Appeals for the 11th Circuit down south said, no, that's wrong. Those cases are in the footnotes. And this issue will be going to the Supreme Court this fall as well. So this is something you really want to watch. But these are the kinds of things, by no means a complete laundry list of that I think labor should do.
Hi, Louis Rocha, CWA Local 9423. Pretty scary that we might be celebrating Labor Day without any labor law in this country for the first time in my lifetime. My question though is, right now there's a urgent call for the Senate to confirm the appointments, and one of the methods, the ways to see that accomplished is being proposed is that they change the Senate rules. I'm wondering what your opinion is if the Senate, if that is a viable option, because right now we don't seem to have many.
Yeah, well, I think it is a viable option. The problem is some of the Democratic senators want to do this at the beginning of this Senate. I'm not really, this is a very arcane subject. There are some who believe that you can only change the rules at the beginning of the session. I don't know what the answer to that is, but there's been one of the things that has made Reid is the guy who is very reluctant to move on this thing. And the one reason the Democrats, a lot of the Democrats don't move is that most of the seats, for instance, this fall of 2014, that could shift, would shift to the Republicans. So the Republicans could, the Republicans could push their own agenda through. The Democrats, I mentioned the pro forma sessions, Democrats also threatened the filibuster in connection with a number of Bush nominees. So there's now, of course, Obama will still be president between 2014 and 2016, and we hope that the Republicans don't get back in 2016. But so this is a real problem where you've got a Republican president and a Republican Senate. But the fear is that this could come around to bite us. That's what really bothers a lot of people. But somebody like Tom Harkin of Iowa has been quite principled and said, "Oh no, we got to do this. This is not part of the democratic system. Look, the system itself is weighted against democracy to begin with by allowing, Wyoming and Utah and Nevada to have the same representation as California and New York. Come on. So that's built into it. Okay, that's part of the Constitution. This is an additional layer. I could go on a long time on this.
So I just also, we're going to try to wrap up in a couple minutes here, so if there's one or two questions more, and I also want to recognize that I think we have 3 elected officials in the room, and I want to thank you all for coming. I see Supervisor Simidian here with us, and trustee from West Valley Mission, Adrian, I saw you, Adrian Gray, and San Jose Unified Trustee, Teresa Castellanos. Welcome. Who would like the last word or two here? Carrie?
I just saw a video review of the Trans-Pacific Partnership and agreement, and I was wondering if you've seen anything on that and have concerns about impacts to workers as well as...
I'm sorry, I missed the trends.
The Trans-Pacific Partnership Agreement, which has been described as NAFTA on steroids by some.
I'm afraid that, you know, I hate to end the evening on a note like this, but I'm afraid that I don't know the first thing about it. So I'm sorry, I can't tell you.
Not many people do, since it's been done in secret. Thank you.
Okay, any other questions?
I'll ask another, because
Yeah.
I'm so curious. I'm very curious what you think about San Jose's lawsuit against Major League Baseball. It's a little bit off subject here, but as I mentioned in my introduction, Professor Gould, he's an expert on Major League Baseball law, which is an area of law all unto itself, right? And maybe you can comment a little bit about that.
Well, briefly, of course, you know that the Commissioner of Baseball really triggered this litigation. The Commissioner of Baseball said, you know, he had no time on his schedule to meet with the mayor of San Jose. And his view of the law, as it's developed, would give him a great deal of comfort in this regard. You know, I mentioned Justice Holmes earlier, and I said that he was a great justice. But like baseball players and law professors, great justices have bad days from time to time. And he wrote an opinion in 1922 called Federal Baseball. It was a case that emerged when a new league, the Federal Baseball League, was trying to challenge what was then called organized baseball, the American National League. Supreme Court said in that case, involving the Baltimore Terrapins, who were cut out of the arrangement between baseball and the Federal League, they sued because they were disgruntled. They said, you know, this is a conspiracy between all these teams trying to restrain trade, put us out of business. Supreme Court said, you're relying upon the antitrust laws, and the antitrust laws require that you be in commerce. You're not in commerce. You're not engaged in the shipment of goods, the business of goods. In part, they're across state lines. You're engaged in the exhibition of baseball games. Now, so this federal baseball decision is really with us today, to this very day. Immunizing, this is why commissioners said, I don't want to meet with the mayor of San Jose, I don't have time to meet with him. This is the way people act, you know, when they're above the law. And his view is that he can do pretty much what he wants, because these geographical enclaves that baseball has established are sacrosanct, because you know, Seattle has, you know, a whole, all the way, I think they got a whole Alaska and Hawaii as well, and we're going all the way to you know, nobody can compete with them. And the antitrust law is about competition. It's supposed to promote competition. So, we thought that this was all going to collapse at one point. We thought, when I was a kid, some guys went down to Mexico and they played ball down there, and we used to play every day. We all day. They had no uniforms, no umpires, nothing. But mothers would give us a sandwich and play all day, every day, all summer. And but we noticed that one year, some of these players were coming back who we had never heard of before, coming into they were already established people, other people, older people, old people knew about them. We didn't know. So these guys had gone to Mexico, and baseball blacklisted them. Baseball said, you're out, you leave us, you're violating the reserve clause which binds you to us for life. You cross that line, you're finished. But baseball was afraid after a decision that in New York that the handwriting was on the wall, so they let these guys come in to drop your lawsuit. But then a funny thing happened, that in 1952, in 1972, a gentleman named Curt Flood played center field for the St. Louis Cardinals. 1968 World Series, his arm was so badly injured he would throw underhand from the outfield, but then he got too old, and the Cardinals wanted to deal him to the Phillies. He didn't want to go. So he sued the Cardinals for baseball for conspiracy and violation of the antitrust laws. He said, you're interfering with my right to make my livelihood. Supreme Court says, no, we're gonna adhere to what Justice Holmes said in 1922. Now, all the cases, virtually all the cases since then have relied upon this federal baseball decision to stop antitrust action. I said, and I was quoted in the San Francisco Chronicle to the effect that these guys who are representing San Jose have a big uphill fight in front of them in light of this. And I also said, Joe Cachette sent me a very nice note saying, he was pleased with what I was surprised that he would send this note to me, because I felt that he would not appreciate the fact that I was saying that the deck was of course I could see how he would appreciate the fact that the deck was stacked against him, because if he's able to do something here, he overcame these great odds. So there's a very attractive case to depart from what we lawyers call stare decisis, decided precedent, and that's what the Supreme Court has been doing. They say, oh yeah, in 1972, they said, oh, they were wrong in 1922. But we have to rely upon it because Congress, baseball has relied upon it. So I think that I think, to sum up here very quickly, if I can, I think that the danger of getting a law professor in with a captive audience. To sum up very quickly, I would say that the baseball will undoubtedly this coming month file a motion to dismiss and say in straightforward language, even if everything that San Jose says is correct, they lose as a matter of law. That's the way they'll try to get this case decided because the one thing Seelig does not want to do, and the one thing that Joe Cachette wants to do, is to depose him and to get him to have to give testimony. Now that's what the real fight is going to be about as this summer goes on and the fall goes on. Whether the baseball can get this dismissed, as we call it, on the papers, saying that as a matter of law you have no case. Appeal it, which will take a few years, or whether they can get to the court. We don't know who the judge is, or at least the last time I looked, I didn't know that it was assigned to a magistrate, one of these magistrate judges. Either side, under Article 3 of the Constitution, can request a full tenured, lifetime tenured judge for this case. I don't know, I don't think either side has decided what they want to do about that. A lot's going to depend on who the judge is. Trial judge, people think, law professors like to think that, oh, you know, the appellate judges are the most important judges because they make the law and they, you know, they issue these decisions. We saw that this week from on high. The trial judges, you know, they decide whether Bud Selig is going to have to testify. They decide how this case is going to be handled, and that is going to be critical in resolving that. And I think we'll know more about how that's going to play out once we see who the judge is. Thank you very much.